Hey everybody, it's John the Gilliam, CEO of Momentum Factor, makers of Field Watch. Really excited about what we have for you today. Let me start with a couple of housekeeping items. David Bland is in Houston now and without power, so we will not enjoy his thoughts and hosting of the session. So I've been asked to step in his stead, and hopefully I'll be able to fill his shoes with this and keep everything on point, as we say. Very excited to have everybody here. Welcome. Appreciate your time. I think we have a fantastic webinar for you, webcast, with these two esteemed experts, Brian Bennett from the DSA and Linda Goldstein at BakerHostetler. First, let me give a shout out for David. He would appreciate if I asked everyone to go ahead and go to the Social Selling News website and subscribe. Everyone on this call is eligible for a free print subscription mailed to your home. And if you just plug in your address, you'll get the next copy of the SSN, which will probably feature a cover story on this very topic that we're talking about today. So he would appreciate that, and that article's coming. So stay tuned and stay abreast of all the news with David's publication, Social Selling News. Okay, so I'd like to introduce the topic here. Actually, let me start with introducing our panelists here. I'll talk a little bit more about what they do. So David is the Brian is the SVP of the Direct Selling Association. He handles matters of policy and regulation at the DSA and has for many years, and is pretty much a subject matter expert there. So perfect for this topic. Hi, Brian.
Hey, Jonathan. Appreciate you having me.
Of course. And Linda handles advertising regulatory law for BakerHostetler and is involved in many investigations and cases at the firm with regard to advertising and consumer law. So thank you, Linda, for joining. And anything you guys want to add to your bios, I would appreciate.
Thanks for having me.
Good to have you. Okay, we are here to discuss a very exciting big decision at the Supreme Court called the Loper-Bright case, also known as a Chevron deference case, which goes back, I believe, 40 years. Lots of folks in the channel very interested, if not some delighted, about this ruling that basically says, going forward, the courts must exercise their independent judgment in deciding whether an agency has acted within its statutory authority, which means ostensibly that the courts should be less reliant on an agency's own experts, i.e. FTC, SEC, FDA, and more reliant on the judges themselves to better define ambiguous rules. Now, we all know in this channel, the rules are indeed ambiguous. So on its face, this appears to be a real win for the channel, at least when it comes to regulatory litigation, but it is too early to say. The case has been decided, but there's much more, and that brings us to our webcast today. So thank you guys for joining. I'd like to start with Linda. Give us a big picture on this ruling. What was Chevron deference? Maybe kind of.
Yeah, thanks, Jonathan. I mean, pretty much as you said, the Chevron doctrine has been the law of the land for 4 decades. And essentially what it said was that where a statute is ambiguous or a law is ambiguous, the courts can give, and actually should give, great deference to the agency that's responsible for the law or the statute in question. So, for example, in an advertising case under the Chevron doctrine, if the FTC, and we've had many cases where this has happened, much to our dismay, where the FTC is alleging that advertising claims are misleading or deceptive, which is the standard under the Federal Trade Commission Act, the FTC could basically come in with no evidence that consumers were actually deceived and basically say, based on our, facial review of the advertising, we believe it's misleading and deceptive. And even in cases, and this has happened to us, where the defendant has brought in empirical evidence like consumer surveys that show that consumers weren't deceived, in many cases, that wouldn't be enough for the court to disregard what the FTC said. So in many enforcement actions, it really was, even though the Federal Trade Commission was the plaintiff, They weren't like a plaintiff in another kind of case. They were kind of the judge and the jury. And what the court said here is basically the agencies do not have the authority to interpret the law. That is up to the courts. And that, the big impact of that from FTC or other agencies is that they will no longer get the benefit of the doubt in cases, which, they've really relied on. And I know we'll get into this a little bit more, but, the FTC has brought some enforcement actions recently where they've taken positions that are really a little out there, and the courts have kind of gone along with it. Again, really because of this Chevron doctrine and the notion that that their views should be accorded great weight.
Wow, yeah. So a big switch from the status quo pre-Chevron. That's great to hear. Brian, so follow-up to this would be, how do you think things will change in Washington, if at all, now that it's been overturned? So what kind of decisions might be made there, or what could be happening there based on this decision?
Yeah, I think just kind of starting off a level set, it's interesting. I was traveling on Friday when the decision was handed down, and my inbox and my text chain was, just blowing up with emails and texts about the decision. I was in the car for 5 hours, so didn't have a chance to really read it or digest it. But when I got to a good place and I read all the news, it was definitely cheered by a lot of people around Washington, D.C., trade associations like DSA, lobbyists and K Street, and specifically Republican members of Congress who said this returns the power to the people, so to speak. Because as Linda said, the kind of pushback against Chevron deference was that these decisions were being made by agencies that were, agencies, Linda, have political appointees. That's great, but a lot of the work is staff driven though at these agencies. So it's essentially not laws by Congress, and these members of Congress are elected. These interpretations of law are made by, for the most part, professional staff of regulatory agencies. So the news was kind of returning power to the people, so to speak. I think, I think back to, for those members in the line, Danny Lee, CEO for Life's our DSA chairman for this term. His big push has been gaining influence. And I don't think he thought that a Supreme Court ruling would be the gaining influence aspect. I don't think he really anticipated that, but certainly I think that's what it is. So the impact here in Washington is more of, when considering legislation, many times members ask, well, what does the agency think? What does the FTC think? The SEC think? All of these agencies think? They're not going to stop asking that, but I think it's also trade associations and, defendants were almost kind of in the background. They started off, definitely, the odds were against them. The odds aren't in your favor, so to speak, as they kind of started off. And it kind of starts as level set, I think, more than anything else. I think amicus briefs filed by trade associations, for example, will have increased interest. DSA filed 2 amicus briefs in the Neora case, which I think Neora said were extremely helpful. Obviously, we'll continue to do that, but I think in terms of the litigation standpoint, those will have increased influence when you kind of look at those decisions. But it's an interesting times here in DC. There's not many legislative days left. Here in DC, we're about to go in the convention to the August recess, and then they go back home for elections. So I think a lot of people are really starting to think about what this means, but don't really have time to implement it. We could see a lot more kind of reauthorizations of agencies, and what that means is how it used to be done. It hasn't been done this way in about 20 to 30 years, but agencies were reauthorized pretty much every year. And if you had to update kind of their statutory authority or anything, Congress kind of reauthorized these agencies. There hasn't been an FTC reauthorization in about 30 years. So I think they can look at reauthorizations of agencies. I think oversight will be an increased kind of priority as well. The FTC actually has a budget hearing tomorrow, but it's really more of an oversight hearing. But here at DSA, I think we've really just, been anticipating this decision for a couple of years now. We've increased our support of FTC oversight of appropriations processes, essentially budget language saying they can't do certain things unless they meet certain requirements. And I know we're going to get into this later. And my final note on this, Jonathan, will be, I think with great power comes great responsibility. And I think a lot of people don't really realize what that is right now. But I think that's going to be an aspect of this as well, that there will be more, specific statutes passed by Congress, which can be good, but can be bad as well. So.
Right, and that's one of the, I think we want to look at the consequences of this, because we know that the rulemaking hasn't stopped at FTC, and Lena Khan is still there. So let's get into that a little bit. So as far as FTC, Linda, what do you think? Do you think this ruling will affect their day-to-day operations as their current priorities, or with the emphasis on new rules and issuing notices of penalty offense? Everyone on this call is familiar with the penalty offense letters that came out in the last few years. So do you think it'll change the day-to-day at FTC?
So, just in terms of their day-to-day enforcement, I don't think it's going to change much. I mean, the Chevron doctrine mostly becomes relevant when you get to litigation. But what I do think could happen, or where it could affect their enforcement, is they've brought a number of cases, particularly under ROSCA, which is the statute that governs subscription marketing and recurring billing, where they have, taken extreme positions on what the statute requires. And they've gone to litigation on some of these. And I think in part because they were empowered by the fact that they believed the court would defer to their views, even if their views were inconsistent with the statute. So I think, it has been very, very difficult certainly under Lena Khan's leadership to settle cases with the FTC, even where we have believed that the positions they were taking were unreasonable. I think it may empower companies who can afford to go to litigation more on those issues. In terms of the rulemaking, I think it's kind of an ironic potential outcome. I think they may try more rulemaking so that they can get a more specific reading of the statute, but I think those rules are going to be much more vulnerable to attack. And we saw this just last week. I mean, I think this has kind of been a little bit of a two-punch against the FTC, because first you had, the dismantling of Chevron, which definitely weakens their authority. And then I believe it was last Thursday or Friday, a district court in Texas that was hearing a challenge to the FTC's complete ban on non-competes, which the chamber was one of the challengers in that case. And the court preliminarily handed down an injunction preventing the implementation and enforcement of that rule. They will issue their final decision, I believe, on the 31st. I think they said the 31st of August, but if you're reading the tea leaves there, they already said and cited Loper that the FTC did not have the authority to issue a rule on the competition side, which is, more on the, antitrust, competition side of the FTC's house. So it's not necessarily binding on what they might do in the consumer protection arena. But I think seeing the court refer to the Loper case in basically refusing to allow the implementation of this rule, maybe it will be, put a little bit of a constraint on kind of the rulemaking frenzy that they've been engaged in for the last several years. But I also think the flip side is it may encourage them to do more rulemaking, perhaps not as extreme as some of the rules they've done, because they need those rules, again, to get money. I mean, the rulemaking was largely a reaction to the Supreme Court's decision in AMG, where they stripped them of their authority to get money under 13B. So I think they'll still be looking to do rules, but maybe they'll be a little bit tempered in how far they try to go with those rules.
Well, that was actually my next question was 13B. So, you know, and I guess you answered the question, do you think that this loss of Chevron will alter their enforcement strategies, like the strategies that they employ to try and get that money?
Well, again, you know, the best way for them to get money is by promulgating rules, because they can and have pushed those through really without a lot of due process. But as I said, I think, you know, maybe there'll be a little bit of restraint in terms of what those trade regulation rules are. You know, on the notice of penalty offenses and enforcement under that, I again think that that whole strategy was vulnerable to begin with, because, you know, the notice of penalty offense authority basically says that you can send notices to companies who are engaged in a certain practice if there was a previous case where a defendant engaged in, or a company engaged in similar conduct that was found to be unlawful. But there was a vulnerability there because, you know, again, that authority goes back decades, and the practices that are in effect today are not like the practices that were in effect when a lot of those orders were issued. But in addition, again, though that whole enforcement strategy is based on their interpretation of, you know, what conduct was lawful and unlawful, and whether it's, you know, what they're challenging now is similar to what was found to be deceptive, you know, 30 or 40 years ago. So, you know, they may turn to that because their, you know, their arsenal is losing a lot of weapons. But I think they may have more challenges with that approach as well.
Yeah, if I could just say, Jonathan and Linda, just a couple things, first on the rule and then on the enforcement. I think on the rules, I think they always need to, Linda, in their notice of proposed rulemaking, A and PRM, state the authority they have to issue a rule, right? And I think in the consumer protection space, it's section 45N typically of that, which they're likely to cause a substantial injury. Sorry, I'm reading from this, I don't want to misquote it. It's likely to cause a substantial injury to consumers, which is not reasonably avoidable by consumers themselves and not outweighed by countervailing benefits to consumers. So rulemakings, they always need to state kind of, and I think if you look at the earnings claims and business opportunity rules, they always need to have a reason that they have the authority to issue rules. I think that will be beefed up as they issue the rules. They might want to go into that a little bit more. They might not go back to the drawing board entirely, but in anticipation of litigation of rules, maybe beef up that kind of section and their ANPRMs and, you know, NPRMs in the future. I think people I've talked to in terms of enforcement, you know, you look at, and Linda mentioned the non-compete, which is a whole other thing, but if you look at specifically Neora, you know, and the complaint to Neora and the decision to Neora, they didn't talk about Chevron once and the complaint. So I think in our space, I don't know how much of an impact it will have. I think it's interesting as well that kind of the blowback on this is that, well, it will require judges to have technical expertise, right, in cases. I mean, again, going back to these cases, Neora, Burn Lounge before that, I mean, the courts get pretty detailed looking at these compensation plans. So I think in our space, they're already kind of doing that. They already need to dig into a lot of this data, and I'm sure their heads spinning a lot of times looking at all the data that they're presented for an industry that maybe they don't, you know, have a full understanding of, and our industry is not unique in that. I know I've seen a lot of kind of press on FDA, which a lot of members on this call are interested in. You know, courts don't have technical expertise in FDA. You know, they don't know the impacts of certain elements of drugs and things like that. And although the agency will be able to put forward their interpretation of it, to a certain extent, they're making judges kind of become experts. So that's kind of the other side of that as well. So I think there's a background and underpinning in kind of the rulemaking process that the FTC might have to do a little more work in those, but I think also enforcement for our space. You know, I think it won't impact it, and I think you still, and something we didn't get into. I think it's a very positive decision, but I think Linda is a very seasoned litigator, you'll agree. It's not a slam dunk by any means against the agency. It's not like you're always going to win against an agency. It puts you on more level footing, but you still have to go in front of a judge. So it's
Correct.
helpful, but it's not, I don't want anyone to come away from this saying, oh, we're always going to win.
No, I totally agree with that. Not at all. And there is another case called the Skidmore case, in which holds that it's not as strong as Chevron was in terms of giving deference, but it kind of still acknowledges that the FTC is expert and their views should be given respect, which is a little lower of a standard than deference. But I agree with Brian. I think again, I said this earlier, but I really think this is how it's going to play out. I think it's going to be a case by case impact that individual defendants will have to make based on, you know, the strength of their case, and the impact, if any, I think would be limited to, you know, cases where the FTC is taking a really extreme position. Otherwise, you know, I think the likelihood is that the courts would probably come out the same way as the FTC.
Well, on that note, and it's, I don't think we discussed this before in our prep call, but if this had been in effect prior to Neora, what do you think the outcome would have been different?
I mean, I don't think so. No. You
I mean, the
know,
judge did
Neora,
defer.
yeah.
The judge did defer to the company in that case, so maybe not. But I mean, I
I
guess
mean, Neora won, so I think it's more of a question of would it have been, you know, Neora won obviously, so I think would have been more of a slam dunk. No, I mean, again, as I mentioned before, kind of where my mind went, Linda, was I looked back at the Neora complaint even this morning in the decision. They didn't mention Chevron once, and it's interesting. I was on a call last week with somebody who I'm sure Linda's very familiar with. I won't say their name on this call, but I'll text Linda after. But they kind of said they spent some time in the FTC general counsel's office. You know, FTC has a general counsel's office who, you know, if there is litigation, the general counsel's office mostly spearheads that effort. And they were saying when I was with the general counsel's office, Chevron was usually one of the last arguments that we made. You know, they still made it just so it's there. You know, I feel like I'm saying all this, and I just want to reiterate, I don't want to understate or overstate the impact of the decision. I know I may be like, you know, the skeptic on this, but it was a very major decision. These are just things that I've been learning the past week on talking to people that I think know a lot more than I do about this. But yeah, I don't think it would have impacted New York, especially since they won. I think we could have looked back on it if the case went the other way, but no, I don't think it would have impacted it.
Yeah, I was thinking maybe more just in the case being brought in the first place, right?
Yeah, I mean, I think that's, yeah, I defer to Linda to that and how she's kind of advising clients, and this may, Linda, change how kind of you advise clients on, you know, I mean.
You know, the reality is it really, I don't think it will have much of a change on how we advise clients, because going in front of a judge, it's still a crapshoot. So I think as a, you know, it's a great discussion for constitutional lawyers, and our constitutional and appellate lawyers. I mean, they're having a field day with the analysis. But I think from a practical standpoint, even in cases where the FTC is not the one that's going after our client, it's a, you know, a class action or whatever, you know that the outcome could very much depend on the judge. And that's as much of a crapshoot as anything. And in fact, you know, what one, I guess, maybe negative outcome of this is you could get courts all over the country reaching different conclusions, whereas whether you like it or not, when it was, you know, basically, to the extent that there was deference, although I agree with Brian, you rarely see that as part of the decision. Even if you didn't like it, you kind of knew where the FTC stood because they, basically the rulings would repeat, what they wanted. So, it may have a little bit of that impact, but it's not going to change how we advise clients much at all. I don't see that.
Yeah, I would add to that. And David had a question for me that he put in the chat. That the balance of power in DC has now shifted, but an emphasis on compliance remains critical for a direct selling company. What are you advising clients that inquire about last week's landmark decision? I think it's similar to you, right? So we've seen over the years a lot of change in the regulatory landscape. None of it really changes the requirements for direct sales companies and their fields to be honest about their businesses, not mislead consumers. So I don't think that'll ever change from the on the boots, boots on the ground compliance standpoint, right? I don't think it makes a difference. Maybe down the road, I don't know, but if you get nailed by the FTC, you may have a better chance in court. But our message is it's a very expensive company killing proposition to wait for that point, right? So you're still on the hook for having a clean house and making sure that that your field is compliant and that you don't get in the spot in the first place. This seems much more of a litigation constitutional issue, which is way down the road for a lot of companies who don't
I
want
think we won't
Yeah.
really know the impact of this for a year. I'm gonna say at least a year. I think the non-compete decision, I think they cited Chevron once, Linda. I looked at the case this morning. I think they cited Chevron, once. So I think we'll see it maybe more kind of down the line, but it's more, I don't want to call it more academic right now, but I think the on the ground impact, the question we always get for rules and legislation and things like that is, well, how is my company going to operate differently from yesterday to today, for example, when this rule or the statute went into effect? I don't think it's anything right now. I think to your point, Jonathan, when the penalty offense letters went out, we had lots of conversations with our members over that. And I mean, we just said stay the course. If anything, they said, look, what we've been doing for the past 3, 5, 7, 8, however many years, walk into your CEO's office and say, this is working. This is why we're doing this. So I think if anything, this is one more thing of this is why we're doing this, because they're going to give us a fairer shake now, especially after New York when they mention compliance and things like that. So I think this just emphasizes the importance of all of this more than anything else.
Do you think that it could change the DSA's approach to advocacy on behalf of direct sellers?
Yeah, I think we need to, and again, I think we're only a week or so removed from this, and ironically enough, immediately after this, we have a call with our government relations and our general counsel committee. So my answer now could change in a couple hours from now, and they're much smarter people than I. But yeah, I think but we also need to take the lead of what Congress is doing on this too, and work ourselves into that. Linda, I talk about FTC reauthorization, if there's something, more specific that you need to talk about for the deception standard, that could help. Just not direct seller specific, but look to see what kind of things Congress is planning to do, especially with the power dynamics potentially shifting this November. So yes, I think so. I can't articulate those right now. Again, it's the conversation around the Beltway, it's almost like a dog caught the car moment a little bit. It's people were cheering this, and they should have. And I agree, you should cheer this. This was, I think, great for, that to give Congress a fair shake, people a fair shake. I think companies a fair shake, associations a fair shake. But when you get down to the nuts and bolts of, okay, what specific kind of things are you going to do? I have not heard much from people. I think we're all still trying to kind of figure this out. So that's a long way of saying yes, probably, but I just don't know how yet. So.
Okay, yeah.
And I think the impact, to the extent, people are cheering, which, I agree with Bennett, with Brian. I mean, I wouldn't necessarily, cheer this as a major victory one way or another, but I think it feels more important because of what the FTC has been doing under Chairman Khan's leadership, and they have taken some extreme positions. But to Brian's point, currently, I mean, Congress, for example, was, and President Biden all over doing something about junk fees, just as much as the FTC was. So, I think we will need to see also, how this does impact what Congress may do in terms of its oversight and reauthorization and, passing more specific statutes. And, sometimes specificity isn't always good. Ambiguity often helps. So I 100% agree with Brian. I mean, I think we have to, wait a while to see how this shakes out, but it's at least from our perspective, it's not affecting any advice in the short term.
And I think, going back to the congressional perspective, because that's, very, very close to my heart, obviously, I think it's difficult to get legislation through right now, and it's easy to kind of just make it ambiguous, handily, because less arguments form for ambiguous statutes. We just say, look, very generally, and then there is a sense that we'll just push it off to the agency to enforce, but here's kind of the general guidelines that they need to have. A lot of disagreements form sometimes when you get into specifics, and it takes a long time. I mean, you think it's hard to legislate now, just imagine what happens when you need to get into very specific things, not only in our sector, but other sectors. You get into very specific things. I mean, deals fall apart based on that. Privacy legislation is, I think Linda's aware of this, is very hot right now in DC. And I mean, that's fallen apart over specifics of things. So I think again, I think it's, with great power, it's great responsibility. And I think it's a good watershed almost moment for, interest to kind of get their, very specific things out there. But that also can hold up the process as well. And you don't want the perfect to be the enemy of the good, but I think it's going to have to be sometimes.
Thanks, Brian. That's great. So Linda, you had mentioned other threats. The FTC is not the only threat to direct selling companies. Can you talk a little bit about the regulatory threats that come from, that are unchanged, maybe from at the federal level or state level, i.e., I think I heard you say on a prep call, this is not a get out of jail free card for anyone.
Correct. Well, again, I mean, you have the state attorneys general that have been, very active in this arena. You have DOJ in cases where it might be really really egregious. So yeah, the FTC is not the only entity at play here. And I will say what we have seen historically, and I hate to say I've been able to see this pendulum swing as often as it has, but when the FTC is less active, you see the state AGs ramp up. So there is always checks and balances, but there's never going to be a time, and again, Brian mentioned this, I'll just reiterate it, nobody should interpret this as, wow, the standards have just changed. The standards haven't changed at all in terms of, what you should be doing from a compliance standpoint.
I think just one more thing, Jonathan, of interest, independent contractor status, there's litigation ongoing. One of the main plaintiffs is a coalition for workforce innovation. I serve as the vice chair of that coalition. Actually, we're litigating the Department of Labor independent contractor rule. I think this could play, I haven't spoken to counsel on this yet, and I don't know if they're going to file anything, but this could play into it though. Because that is a very broad interpretive rule that they have. So that could be another avenue here that relevant to this audience could also play into independent contractor. And again, you'll see kind of the fruits of this more quickly in ongoing litigation, Linda. I'm sure there's going to be parties, filing things and saying, because of this decision, you need to kind of level set yourself a little bit and not look to this as much. I think the judges know that, obviously, but I think it'll, examples like the non-compete rule and the independent contractor rule, you're going to see the impacts of that more immediately than future litigation, which could take, a year or two down the line. So,
I mean, one of the things I'll be interested in following, but again, this isn't going to be evident until you see a series of cases, is whether it will change the approach the FTC takes in litigation. Because as I said, in many cases, they come in with, little to no evidence of harm or deception, and the companies being challenged, always have the burden of producing evidence to counter what the FTC is saying. Whether they will change that strategy and feel that they need to put on a stronger case from an evidentiary standpoint. It's possible, but I don't think we'll know that for a while until we see a series of cases and how the FTC approaches it.
That seems like the core of the win to me. Not being, an attorney or any of this knowledge, but from a layman's standpoint, if they have to produce more, they can't produce more, which we saw in the New York case. They didn't really have good evidence. Do they sue? Do they go forward? Do they settle? Right? There's a lot of questions there as well that as you say, will come up later in the cases. But thanks for that. Brian, do you think we'll see, on that note, more companies settling with FTC going forward?
Yeah, I don't
Is there
know.
new access to fighting the regulatory decisions in court, do you think?
Yeah, I mean, I think it's, and I flag a quote actually from David Vladek, who was head of the Consumer Protection Bureau, and I think during late Obama administration, I believe, Linda, but he said for quite some time, I think, Chevron has been dead. Now it's, not really cited anymore. So again, I don't know. I think it depends on the facts of your case, I think, and how comfortable you are, because I think, and I saw, kind of preempt this a little bit, Jonathan, I saw a question in the Q&A about what this impacted VEMA. VEMA was a settlement. So again, it would not impact settlements per se. You have to go in front of a judge for it to impact it. And I think, Linda, as you've seen, and your colleague Daniel Kaufman, I forget the number, but he cited, and I think this was not official, it was a very off the cuff, but he would know better than anyone else. I think it was 80–90% of cases end in a settlement. I don't know if that's just because they think they can't win in court, or they don't want to, go through the expense in court. I don't know, but I mean, maybe this plays depending on your case and depending on the evidence, but I think it's just very case specific and dependent.
Okay, thanks for that. Brian, any other thoughts on compliance management before we get into the questions from companies regarding this? Like, what should a company be doing now? What's a takeaway from a compliance standpoint, regulatory standpoint? Any areas of relief from a day-to-day standpoint?
I don't think from a day-to-day standpoint, but I think discuss this with your C-suite. I think, and I know, Jonathan, you've been on top of this as well. And I know we have at the association about making sure that, members of the C-suite not in legal or compliance kind of understand the value of it. And I think this is just one more example. So I think just attempt to get as many eyes on this in your company as possible, just to make sure that, this is one more thing. This is why we do it, because I've heard the jokes before. I've been in the room, your business prevention department, I get it. I get it. But I think this is just one more reason that, the C-suite should be behind you and be your advocate and, support you on these issues. So day to day, no, but I think just attempt to get more support and, socialize this amongst your C-suite. As I say, this is why we're doing these things.
Excellent. Any last words on that, Linda, before questions? I don't see the questions here, so I might ask Mike to ask them from his panelist view. But Linda, any last thoughts on the day-to-day or thoughts that can.
No, I completely agree with Brian. I don't think it in any way lessens the need for a robust compliance program. And I would not suggest that companies devote less resources to compliance. I think they should continue to do what they're doing.
Okay, fair enough. I think the two questions we have, I did find it, Mike. What was the Avema question that Brian answered, and then another Avema question on whether it would have affected the initial stages of the injunction, or when the court issued the injunction. I don't know if you answered that.
Because I think if you remember, and again, this is a whole other issue, but that was ex parte. BEMA had no idea they were even being investigated. So they didn't even have the chance to talk to the FTC prior to that. If you talk about the judge's ruling, would it have impacted it? You know, again, I have to look at that complaint again to see if they use Chevron, but I would think they did not, but I would have to look at that complaint.
Okay, thanks for that. Any other questions? It's open. I'm surprised we have a couple hundred people on this call and 2 questions about the same company. Actually, the Vima case brings up a thought of mine, is that, and I think on our prep call, Linda, we talked about another case that might affect the ability for companies to go after the FTC for an unjust lack of due process, something along those lines. Can you, if you can recall that, can you kind of talk about that a little bit? Because I thought that was really interesting for the space.
I think what we were talking about is in the context of FTC rulemaking, that when Lena Khan became chair, the FTC sort of quietly changed some of the procedures for rulemaking so that they could essentially be more truncated, and there was less due process. And we've seen that, for example, most recently in the negative option rule, after they issued the advance notice of proposed rulemaking, they made a conclusion that there were no disputed issues of fact, and essentially kind of bypassed the hearing when some of the commenters said, you need to have a hearing, you need to do that process. The hearing was giving 6 commenters rather, the opportunity to speak for 10 minutes. So, I think to the extent that the FTC is doing that, it may be, more subject to challenge, but I don't, that's not a Chevron issue. I mean, I think it's just important to remember that Chevron, that doctrine is very limited doctrine that basically says if a statute is ambiguous, the court should defer to the agency with oversight to enforce that statute and their expertise. And I want to say also that not just the Skidmore case that I mentioned, but just in practice, as Brian said, we rarely have seen a judge expressly refer to Chevron, but they do view the FTC as having expertise in the area. So while they don't, need to give them deference, they're human beings. And I think always in court, hearing what the FTC is saying is going to have an impact on a judge, regardless of, whether you call it deference or just another factor that they consider in reaching their overall decision. I do think, maybe for some other agencies like EPA with the Clean Air Act, it's something like that. I think it could have a huge impact, but in terms of our industry and the advertising component of it, I don't, again, not to keep repeating, but I don't see much day-to-day impact. of the decision.
Yeah.
Well, the difference between the words respect and deference, there seems to be a pretty big gap there if you're a judge being told how to handle a case, right? So who knows how that'll turn out. We'll watch the cases as they proliferate. We have one more question from Andrea. Do you guys think more companies will be taking the route of Advocare or more recently Saint proactively? I'll answer the first part of that. I think those cases were due to pressure, Advocare's pressure in its case, Saint's pressure in the marketplace. And so Saint, as some of you know, went affiliate just last week. And so we're seeing some companies toy with that. Are they effectively out of the space depending on their comp plan? Maybe. I think they were going to a 2-level. So I don't know that applies as much, but I don't know if you guys have some thoughts on that question. And maybe that's more from a legal standpoint.
Yeah, but I think my answer will be the same because again, Jonathan, it's the Advocare and the Saint situation. You said, well, there are different motivations for each. Again, going back, it's case specific. I hate to, I hate to keep saying that, Linda, right? It just depends on your case, I think. And again, judges, I mean, again, we saw in Eora, we saw in Burn Lounge, we've seen a lot of cases in our industry, especially when they talk about compensation plans. I mean, the blowback of the side who was not supportive, or I'm sorry, was supportive of Chevron staying in place was, we're going to have to make judges really get into the weeds and things, and they're not experts. I've seen in our cases, judges have gone into the weeds. I think they need to. And yeah, they do respect what the FTC says, but I mean, Judge Neora really got into the weeds. Like, I'll give her a lot of credit, like really got into the weeds on this. That's why I think it took so long for her decision to come out. She got into the weeds on it. So yeah, I hate to keep, repeating myself, and we talk about what has impacted things that happened. Probably not. But again, I think there are different motivations with different companies that nobody on this line, unless you are your counsel, and if Linda was any one of those counsels, she probably couldn't talk about it publicly, but that's a conversation you need to have with your counsel and the cost and the benefits of it. So.
For sure. Well, thank you guys. I think we'll leave it at that. I think I really appreciate your time here. I think this is a great topic, and this is good news. Let's reiterate. We're getting into the weeds, and we're looking at lawyers on the phone. So, but this is good news for the space, and we need all we can get. And I think it's just wonderful to see some things moving in the direction to help companies conduct business while protecting their field. So. Appreciate you guys both so much. Go and subscribe to Social Selling News, guys. If you're not getting the print copy at home, just go to the site. It's free. And thank you, Brian and Linda, for joining us. And we'll do this again.
Thanks all.
Glad to be here. Thanks.
All right. Bye, everyone. Thank you.